Hello, my name is Jim Cole. I served for over 20 years as the general counsel for Missouri Right to Life before I retired. Now I'm happily retired, but I do some projects for Missouri Right to Life, and this video is one of them. I'm here today to talk about the durable power of attorney and how that fits in and actually is needed for pro-life people to protect themselves in the case of when they get to be incapacitated or unable to give healthcare decisions. How a durable power of attorney would be very well worth their time to have in place if that ever happens. Or one basic thing I want to say also is that I'm not here to give legal advice. I'm going to be talking about legal matters, but it's in the way of general education. I'm not giving anybody any advice as an attorney. I urge people to find their own attorneys for any kind of legal advice. And secondly, I want to dispel one, I think, misconception that people have about the pro-life movement in regard to end-of-life issues. And that's that they think we want to have people live to the last possible second and not try to allow them to in any way get treatment that actually may result in a shortening of life, like some patent treatments act that way. We know that we're human beings. All of us die. The mortality rate of the human race is still 100% last time I checked. And there is a time to die. We recognize that. We're not here to force people to live beyond the time that's naturally accorded to them, but we do want them to live about that long, whatever time nature has available for them, not somebody else's decision on how to end their lives before the natural time of death. So with those things in mind, let me turn to what the subject matter is, and that's the need for a pro-life durable power of attorney. We need that because there's a pro-death movement in this country. It's not nearly as loud, it's not nearly as visible to the ordinary person as the pro-abortion movement, but it's still just as lethal, and it's gaining in its effects and its influence in the United States, just like it is in a lot of other countries in the Western world. We have the example of our neighbor to the north, Canada. They've got a law and have had a law since 2016 that allows a person who is diagnosed with a condition that would probably result in death within 6 months, and they have some kind of pain. It could be emotional pain, it could be physical pain, but some kind of pain that goes along with it, and a doctor says they're still in their right mind. With all those three things in mind, they can get a lethal injection. Just like in prisons or in other situations, veterinarians put animals down. This lethal injection is a way of putting a human being down. And all they have to do is get a doctor's prescription after the things that I mentioned, and then they get pills to take, and it's up to them whether they take the pills or not. Well, that's the kind of law that's spreading, and here in the United States, the state of Oregon was the first in the country to adopt such a law. But we have 10 states now, and then the 11th would be the District of Columbia, Washington, D.C., that allows that type of thing to happen. The way it grows is because people are shunted that way in hospitals and in other areas where they're getting medical attention. And one Canadian expert in this area, in fact, a doctor who serves on the provincial board of medicine for the province of Quebec, she has written, after looking at the records, that it's easier a lot of times for a patient to ask for that kind of death and receive it than it is to get regular medical care, like wheelchairs or things like that to help people. And here in the United States, we see that states have adopted the type of, they call it the Medical Assistance in Dying Act, MAID for short. states that have adopted MAID laws, like Oregon and Vermont and other places, they tend to start out saying, oh, we've got a lot of safeguards against abuses. And they talk about waiting periods. They talk about the doctor's examinations that are needed. But then after the laws are instituted, they'll come back again with propaganda, as I consider it, that basically says, oh, those are obstacles. We have to widen the scope of the people who can receive this medical treatment, this medical aid in dying. So in Canada now, because of the way they've liberalized their laws, in Canada, a person can receive MAID with much less notice than, or waiting period, I should say, than was originally enacted into the laws. Some people can get MAID assistance in 2 days after the first request. That's hardly time to consider where you're going to stay in the hospital, or stay in a hotel. And in Oregon, it's about the same way. In Oregon, they've got laws that have reduced the waiting period, that have widened the scope of who's eligible. In Canada and Oregon, I think that emotional pain is supposed to be measured, however you do that, and in whatever format the doctor chooses. In those places, advanced practice nurses rather than doctors do the assessments and do the medical examinations to see whether or not the person is eligible. And it doesn't have to be death within 6 months. That's predictable now. It's any kind of incurable disease or incurable condition. So the pro-death movement not only falsifies what it really is standing for when they do advertisements and get laws through legislatures right at the beginning, having said that there are all kinds of safeguards to keep it from being abused. It ends up being abused because they end up getting the law changed to remove these obstacles to the treatment, they call it, of people's pains and infirmities. So we have the MAID movement is advancing. In fact, one more state was added in 2025, just this year. In Missouri, a bill was introduced last year to have MAID in Missouri. It didn't go anywhere, thank goodness, but you don't know what's going to happen. We found that out in the abortion context with Amendment 3, the old Amendment 3, I should call it. So we have to be careful of what we are thinking about as pro-lifers and protecting. We have to be advised, really, to protect ourselves with something that would stop the juggernaut of the MAID state of mind. In states like Missouri that don't have MAID, they still have ways of trying to dispatch of people a little bit too early. And one is through withholding nutrients and hydration from patients that need them, just like anybody else needs food and water to live. I mean, nutrients and hydration is just food and water in a different form. And a lot of times it gets to the point in medical treatment where they're delivered by tubes to the stomach or tubes to the throat, tubes through the nasal passage, down the windpipe or the esophagus. So by withdrawing something that people need to live, that accomplishes much the same thing in a slower fashion than the MAID laws does. And they have established, they have initiated websites now by some organizations that show people how to write a durable power of attorney that allows their consent to the withholding of food or nutrients ahead of time, so that when they reach the point of incapacity where they can't make their own decisions and somebody thinks that they ought to be starved to death ahead of time, then they can invoke that clause of a durable power of attorney that's written the wrong way and be starved to death. And it's so bad, it's so inhuman a death You can hardly imagine what it's like. But a lot of times, at least the websites that I've seen, they urge people to enter these things and check a box that says, this is my irreparable, or I'm sorry, irrevocable decision of how I want to be treated. And if I get started on one of these starvation routines, in fact, they've got a name for it. It's voluntary stopping of eating and drinking, VSED. If I get started on one of these VSED programs where I'm denied liquids, I'm denied food in liquid form through tubes or whatever, and then if I come begging to get I've changed my mind, if I come begging to be fed, be hydrated, you're supposed to ignore me, because my choice when I was competent was that I wanted to die this way. And by golly, that's what you need to do. And they'll do it. And then they'll write an official cause of death on a death certificate that says that the cause of death was whatever the underlying condition was that caused them to be incapacitated, rather than, oh, we starved him to death, if that happens. So the pro-death movement, I call it, is advancing stage by stage. And that's just a few examples of what they're up to in America and in Missouri, as well as in other parts of the world. In Canada, when they first enacted their law 8 years ago, they had just over 1,000 deaths by MAID. That's the one where they actually inject or have the prescription pills and inject people if the doctor's willing to do that, which they really are not. In 2023, 8 years later, the number of deaths was 15,000 and some. That's a 1,500% increase in 8 years. And the numbers keep exploding. In other places, in Belgium, for instance, not only do they have the same kind of expansion, they use lethal means of causing the deaths of children, of minors who can't really consent for themselves. And in Great Britain, we've all seen the stories, I think, of babies that have some kind of impairments, and the hospital wants to terminate the treatment. The parents object. They want their child to be treated. And if it's a natural death, it's a natural death, but it's just an infant. The British courts have ruled in several high-profile cases that it's going to be the hospitals whose medical determinations are going to be followed, and that the parents don't have the final say. And they've actually refused offers, especially from Italian hospitals with Catholic backgrounds. They've refused offers to have the child transported from Britain to Italy, and to have the child cared for at no cost to either the government's health system in Britain or to the parents. And the British courts have refused those. It's just, it shows a mindset that's really cruel and really pro-death in the worst senses of the word. Those types of attitudes are growing in the United States. When they do public opinion polls, most people approve of denying food and water to people who are in a helpless condition. And it's the hopeless attacking the helpless, as I think of it. It's terrible. But we've got to deal with this somehow. And one thing we've got to deal with is our own personal lives and how we would like to protect ourselves against that attitude and take whatever course is necessary for a natural death, but not to violate our own pro-life principles by endorsing anything that would cause a premature death. And unfortunately, the online forms of durable powers of attorney that you can download often have check the boxes routines. I don't want, if I'm incapacitated and it looks like I'm going to be that way for a long time, I don't want food by tube. I don't want special types of treatments in other areas. And they have a whole long checklist. And some of them even include things like I don't want to have antibiotics. I don't want to have surgery. If you get an inflammation from somewhere that doesn't have anything to do with your long-term condition, except the flu bug happened to hit you or something, you're signing away your right to get treated in ways that don't amount to any serious condition. They're side issues to what may be incapacitating you. But that kind of instruction is way too broad and way too common, and a lot of people support it. So we've got a real movement here that we need to protect against. And that's why I'm urging people to enter into pro-life durable power of attorney. And I'll explain what a durable power of attorney is as we go along, and what the pro-life principles are that will take us into a form of durable power of attorney that would be pro-life and would protect us for our natural deaths, and without giving permission for anything that would lead to an unnatural and premature death. Now, I think that, just as an aside, none of us really like to talk about death. None of us really want to consider ourselves as facing death sometime, but we all do. Woody Allen, he's a humorist from a while back. I don't know if the millennial generation knows who Woody Allen is, but all the baby boomers would know him right away. He once said, I'm not afraid of death. I just don't want to be there when it happens. Well, that's kind of the attitude that keeps people from getting into this area and thinking about a pro-life durable power of attorney. But we really need to think about it. That's one of the reasons why I'm here making this video today. Let me read you what a local pro-life person that's very well versed in end-of-life matters has had to say about this voluntary stopping of eating and drinking that I mentioned just a few minutes ago. That's Nancy Valco. All of us who are in the pro-life movement will recognize Nancy's name. She's a wonderful woman, has devoted a lot of time over the years to the pro-life cause, and she's a retired nurse and very good at her job, or was very good at her job when she was active. She says that she read an article in the Journal of the American Geriatric Society. Geriatrics, of course, is the medicine applicable to older people. The article said, VSED is an intense process fraught with new sources of somatic and emotional suffering for individuals and their caregivers. The most common symptoms encountered after starting VSED are extreme thirst, hunger, of course, who would have known, dysuria, which is painful urination due to concentrated urine, progressive disability, delirium, and somnolence, which is unconsciousness. And the authors further state, because an individual with delirium may forget his or her intention and ask for drinks of water, caregivers will struggle with the need to remind the incapacitated individual of his or her own wishes. This possibility should be anticipated and discussed with the individual in advance. While reminding the individual of his or her prior intentions may feel like coercion, acquiescing to requests for water will prolong the dying process for someone who has clearly articulated the desire to hasten death. Well, there may have once been a desire to hasten death, but when you actually face it, it's another thing entirely. And for these people to insist that only one choice is valid and it can't be revoked is just cruelty. We've got several types of pressure that kind of lead to the increase in support for that type of thing that I mentioned before. There's people have a fear of pain, fear of death. That's natural. There's fear and shame on becoming a burden on relatives or other caregivers. It's also natural. Resentment at losing the abilities to take care of yourself with meals, hygiene, ordinary things, of course. There's loss of faith in an afterlife and becoming socially isolated from friends and neighbors so that you're lonely. So all those things are social pushers in favor of calling it quits and allowing death with dignity, so-called. And then there's financial pressures coming up. They keep announcing every so often that Medicare and Medicaid are going to run out of money and they won't be available for health care costs in about 10 years. The latest I heard was about 3 or 4 months ago. The extrapolation was that it would actually be about 2033, not any later than that, if nothing is done to refund and put some more money in. But I don't think most people are thinking of those costs, but the pressure is going to be there when people do start thinking of those costs. So to go along with that, we've got a push by respected legal organization to have people sign or have the authority for making decisions for incapacitated people devolve onto a person involuntarily, so to speak. What I'm talking about is there are too few people in the minds of a lot of healthcare leaders that have entered into durable powers of attorney. So they've got a law that's proposed by a group. It's a very influential group. It's the National Conference of Commissioners on Uniform State Laws. That's a mouthful, but that means that they issue model laws for legislatures in all the states to enact. And then hopefully if they enact them, people who move from Missouri to Iowa or Oregon to California will know that the rules are essentially the same for cashing checks, for other kinds of transactions. Well, they've got one of those for healthcare decisions too. It's called the Uniform Health Care Decisions Act. There's a version of it that's pending, or not pending, but in effect right now in most states. But in fact, a lot of people haven't, in the minds of these lawyers and doctors, a lot of people who should have durable powers of attorney haven't invested in them. So we have a situation where they've remodeled the law, so to speak. They're going to replace the existing law if legislatures enact these things. They're going to replace the existing law with the new law that they're proposing as of 2023. I've looked at that law a little bit, or that proposed law, I should say, myself, and we never know exactly what it's going to turn into when it hits the legislature, and the legislature toys with the language and considers things. But one objectionable thing is going to be how they handle the idea that there's an agent for somebody who's incapacitated and can't make his own decision or her own decision and hasn't given instructions in advance through a power of attorney. And that's to establish what's called a default surrogate. A surrogate is a fancy word for agent. Default, in this case, means if there's no designation of an agent by the incapacitated person, then by default, they would pick one. The they would be either doctors or hospitals who are treating the patient, and they have a proposed treatment that has to be consented to, or else it won't be put into effect. But if the patient's incapacitated, the incapacitated patient can't give consent, at least meaningful consent, informed consent. So the idea would be that when that occurs and the patient doesn't have a durable power of attorney, then they would begin with the closest relatives, the spouse or children, parents, and start seeking them out to see if they can get one to say, yeah, I'll serve as the surrogate and make medical decisions for my aunt, uncle, mother, father, brother, whatever. The person would have to say they agree to it, but they wouldn't necessarily know what their incapacitated relative would do in such situations. And the idea of a surrogate is as an agent to serve the interests and the needs of the patient, not themselves. So if they haven't thought through things themselves, that's an additional burden. But if they haven't ever had decent conversations about this type of thing with their now incapacitated relative, then they've got to rely on their own judgment of what they would like, maybe, instead of what they know the judgment of their incapacitated relative would be. And if none of the relatives are willing to do this, then they'll pick somebody who supposedly has some connection with the incapacitated person as a friend or as a live-in, or in the end, it talks about people who have had knowledge of who have had close relations with these people for a while and think they know what the person would have done. It's very loose and very loose, excuse me. It's a very loose standard for trying to pick a surrogate to make life and death decisions on behalf of an incapacitated patient. That's another example of what I would call the pro-death movement, because usually when these proposed treatments are proposed, you have relatives all pretty much agreed on what should happen, and the spouse and the children typically reach some kind of agreement. But if they can't reach an agreement, then that means somebody wants to deny the treatment and somebody wants to incur it. There can be a pro-life and a pro-death side to that within the family. They could be at loggerheads. The doctors don't know how to sort it out. So you got this default surrogate that the hospital or the doctors are going to be searching for and recruiting. And you just wonder, well, are they going to take notes on conversations with all the relatives to figure out which ones are pro-death, so to speak, which ones are pro-life, so to speak, and then pick the one they like better to say yes or no, so that the hospitals have somebody they can turn to, and there's going to be no fight about it because that person's going to do what the hospitals want. That would be an abuse of the whole situation. That would be an abuse of trying to find somebody who's an agent of the incapacitated person. But that's the aspect of the pro-death movement that's coming down the road to Missouri, probably in 2027, and not this coming session in 2026. So if you lack your own durable power of attorney for health care, you're one of the targets for this movement. And if you are incapacitated or unable to communicate health care decisions, you don't know really which way your doctor is going to be tending or what his philosophy of life is. You're going to be subject to it. Now, there are pro-life opportunities in these situations, and one of them is, and a powerful one is, to enter into a durable power of attorney. And now it's a good time for me to tell you what a durable power of attorney is. We have in this country a legal principle that says a person who's incapacitated can't, of course, make decisions on legal matters. Well, in healthcare, it's called informed consent, and the rule is that a person can't give informed consent to a treatment if they're not capable of understanding what's going on. We've all signed the informed consent documents. Every time we go to the hospital and something is treated, one of the pages that you're going to sign is going to be an informed consent statement. An informed consent is something that requires an explanation to you, or to somebody at least, of what the situation is, the diagnosis, the medical diagnosis, what opportunities for treatment are available, and what the result would probably be with the different ways of treating something or not treating them, as the case may be. That would be the prognosis. And then you have the the need to make sure that the proposal is understood and that the doctors need to have a decision made. And then the durable power of attorney is the patient's advance appointment of a surrogate or an agent to make these decisions in light of informed consent. You can see that since informed consent requires knowledge of the conditions as they are now and not as they might be in the future sometime, you can't have informed consent by the patient himself or herself if he or she gets incapacitated before the need for treatment has actually come up. So appointing an agent who is there and will obtain the information needed to make an informed decision and who will weigh that against the desires and wishes of the patient that were made ahead of time, the principles of decision. That the agent is there to take the place of the principal and to do what the principal would want, the patient, not what the surrogate would necessarily want in his or her own situation. So one of the things that we can do is adopt a pro-life durable power of attorney. There are several principles that we want our agent to follow, and I've written down and explained a few of them so that people know what kinds of things we're talking about. I'll give a little summary of those, and then a general rule for a rule of decision, they call it in the law, for how the decision should come out if you have certain types of evidence and other types of evidence and that kind of thing. One of the principles is that life is good. Life is a gift. We don't ever cause ourselves to be living, and we are always cognizant that we should not make death premature. We should always fight for a natural and a natural death. That's just a fundamental principle that we start out with. We say no to objections and claims that a person's life is futile. And some of the futile language is not just because of pain, but it's because that he or she has a condition that cannot be completely cured. Now, as I sit here today, I have a condition that can't be completely cured. It's called diabetes. And for somebody to try to put me to death if I was unconscious, couldn't make my own decisions, and if somebody would call my life futile because I'm unconscious, they don't know how long I'm going to be unconscious, but I've got diabetes and can't cure that, so we're not going to treat this patient anymore. Well, that's ridiculous, but that's what the futile argument boils down to, is that basically that somebody who's never going to get better and can't be cured shouldn't be allowed to stay the same, shouldn't be allowed to have their life extended as much as we can for a natural death. So that's one of the principles involved. Say no to the theory of futility. Another one is to say no to quality of life issues. Quality of life, what qualities make quality of life? Well, that's going to be different for every person, it seems like to me. It's a very subjective, non-scientific way of looking at these questions. So we don't believe in qualities of life as the measuring rod for whether a person lives or dies, no matter what condition they're in. And a lot of times people give up, outsiders give up too easily because there may be a bad quality of life in some people's minds, but that doesn't mean that they can't improve their quality of life by continuing to live rather than be forced to die. And we say no to death with dignity. Death with dignity is one of the favorite phrases of the pro-death movement. Somehow it's more dignified to be a corpse and to be made into a corpse than it is to continue to live and deal with the problems that you have as a medical matter. It's really giving up on a person entirely. And what the proponents mean by dignity is beyond putting into objective criteria. And you see doctors sometimes put articles into medical journals about the components of dignity when you're talking about an end-of-life situation. And if you collect those and try to read them, they hardly ever agree with each other. I mean, most people would say, of course, that being relieved of pain gives you greater dignity. You feel better anyway. But what is it that makes a person dignified? It's more a matter of including some spiritual components, maybe, huh? And maybe some other unscientific components that can't be measured by numbers and by milligrams. There's a lot to that. And so you don't improve anybody's dignity of life when you put them in a position where they don't even have life anymore. There's no dignified corpse. There's nothing dignified about making people into corpses rather than trying to treat what they really face. So what we're left with doing is having an agent in place that learns what the patient is undergoing, the diagnosis and the prognosis, and the different kinds of things that can be done under a prognosis. We have the agent who's there to make those kinds of decisions. The agent should have talked at some length, hopefully, with the patient at some point to memorialize what it is, so that the agent knows what the person wanted to have done in end-of-life situations, and can give a judgment based on the patient's weighing of how those things should be handled, rather than the surrogate or agent's own system of philosophy on that. We also end up with benefits that the treatments are supposed to provide or were expected to provide. We end up with burdens that might be side effects of certain treatments, and we need to weigh those. And the ultimate decision-making ideally would be that the agent has a list of the benefits of whatever's proposed and other alternatives, and then has a list of the burdens of what can be proposed, and what different alternatives might be. And in the event that there is a need for a decision, the decision should be whether or not the proposed treatment or non-treatment of specific medical problems, such as infection, such as a tumor, are substantially outweighed by the burdens that the proposed treatment or non-treatment may cause, such as increase in pain, loss of mobility, things like that. If it is substantially outweighed by the burdens, then the treatment that would provide the benefits can be foregone. And that's a very, I think, a rational way of approaching it. But at all times, I insist on this. Life is a gift to be protected and is not itself a burden. Just because a person is alive doesn't mean that the living part is a burden, even when there's serious affliction, serious other kinds of problems. And the last thing I want to say is that there are different kinds of pain. There's physical pain and emotional pain. The physical pain can be dealt with in large part by drugs and other treatments. And if necessary, then you can get into the area of whether or not consciousness should be sacrificed for pain relief and how to balance those out. And there's an advantage to having some consciousness, even if there's some more pain, because you're conscious. Because this period of end of life for everybody can offer opportunities for reconciling yourself with other relatives or with friends. And it may depend on the area of the amount of consciousness you have, but you have that opportunity. And it's even a time to get right with God for believers, and maybe a special time for that. So life itself is not the burden. It's always whether or not the burdens of the treatments focusing on the exact problem that's presented medically, whether the burdens outweigh the benefits of the proposed treatments, again, looking at specific things medically. Now, I have more to say about the Missouri Right to Life durable power of attorney, but I've laid the groundwork for what is happening in this country and what kinds of things, principles we need at least. And I'll have another segment of this video, and I'll have another segment. I'll have another portion of this video in which I address some of the particulars of the Missouri Right to Life durable power of attorney, explain more of what it is, how the agent should be picked, and then conclude with how to how to record what you want so that when the time comes, the document can be found and the principles can be followed. Thank you. But let me explain what a durable power of attorney is. A power of attorney in the law is simply a designation of somebody to serve as an agent for somebody else. You have a principal, and that's the person that's being served. You have the agent who's doing the serving. A durable power of attorney has the adjective durable because it can last after the principal has become incapacitated. Under ordinary civil law in Missouri and in most other states, if not all, a power of attorney expires when the principal who gave that power of attorney has reached a state of incapacity or dies. The durable power of attorney is a legal invention of the 1980s in which the power of attorney continues on past the incapacity of the principal. That's why it's called durable. And then the specific designation of a healthcare power of attorney deals with the fact that the agent is going to be handling healthcare decisions, and there are special considerations, such as informed consent, that have to be met before the agent's services will no longer be necessary, or in fact, it's to obtain informed consent that is the whole point of appointing an agent under a durable power of attorney. That's in very brief terms what a durable power of attorney is as a document. The document is signed by the principal, and some states require witnesses. Missouri does in certain limited respects. I'm not going to get into the Missouri signature requirements until we talk about the form itself. There's a little bit of a mismatch between two laws that have been kind of combined in Missouri into how durable powers of attorney ought to be carried out in the healthcare area. So I won't get into that. But the appointment of the agent is as simple as name of principal. I, name of principal, hereby appoint John Doe as my attorney in fact, sometimes called healthcare agent, to carry out my wishes in such times as I might be incapacitated or cannot communicate my desires that would govern a decision in the healthcare field. So it's written in advance of any period when the principal is unable either to understand and make decisions in capacity or cannot communicate. Sometimes you have people, hopefully that's a very low number, but you have people that are in what's called a locked-in syndrome, where they can hear perfectly fine, some can see perfectly fine, they just can't move. And they have the inability to speak, so they can't tell people even that they're conscious. A lot of times they've been diagnosed as being unconscious, but it's a locked-in syndrome. So you've got both the understanding component and the communication component of the term incapacity here. Now, just as a side remark, in the 80s is when all this came to the fore with people like Christine Bousalaki and Nancy Cruzan having had to go, their families had to go to court to determine whether or not they would be starved to death and dehydrated to death after accidents of some kind. And the doctor at the time was a well-known pro-death proponent. He examined Nancy Cruzan rather cursorily and declared that she was a candidate for stopping her food and water. They had a fight that actually, the first part of which the state of Missouri entered in because she was hospitalized at a state hospital in southwest Missouri. And we actually won a decision from the Missouri Supreme Court that said that they had not shown they had not shown with clear and convincing evidence that Nancy Cruzan was on her deathbed or needed to have any other medication or any other treatment than what she was already receiving, and that it was not a burden to her to receive food and water via tube. The case went to the U.S. Supreme Court on a technical issue that has been largely ignored by most lawyers and people ever since. But the issue was, could the state of Missouri, by its Supreme Court decision, make somebody who wanted to withdraw treatment that would end life, that they make their case by clear and convincing evidence. Now, clear and convincing is a type of proof, it's a quantum of proof, I should say, that's more than just a preponderance of the evidence. Let me step back a little bit into legal mode. In civil lawsuits, it's different than it is in criminal cases of prosecution. In criminal cases, to find a defendant guilty, you have to prove the case beyond a reasonable doubt. That's the highest principle in the law for the amount of evidence needed to accomplish the result. In the civil side, like ordinary lawsuits on accidents or on money owed or adoptions, things like that, that don't involve criminal prosecutions, the standards of proof begin with preponderance of the evidence. In other words, in order to get a judgment of somebody's negligence and they owe money to somebody else, the evidence for the proponent, the plaintiff, has to be just a little bit more than what we would kind of call half of the evidence. And that's a matter of judgment that is not just mechanical, assign a score to something and then see what the scores are. It's a feeling of, is the evidence believable? Is it solid? Is it something that really has an effect on this case? And a lot of times evidence will be admitted or not admitted according to how a judge sees it, according to the rules of evidence. Once the trial is done, all the evidence is gathered together and given usually to a jury, sometimes to a judge. But the jury has to decide, well, which side has the better, more quality preponderance of the evidence. More like 51%, so you will, so in some cases. But that's a very rough way of saying what I'm trying to get by. But preponderance of the evidence is the ordinary standard. Clear and convincing evidence is much higher. It's not beyond a reasonable doubt, but it means there isn't any real substantive evidence besides maybe speculation or what is kind of weak when you look at the circumstances. It has to be pretty darn close to beyond a reasonable doubt, but not quite. It's not quite that bad. So preponderance, or the standard of clear and convincing evidence was what Missouri required to put Nancy Cruzan to death. They didn't have it in the first trial that was appealed to the Missouri Supreme Court. So the defendants who wanted to put Nancy under appealed to the United States Supreme Court to say it was a violation of due process of law to require clear and convincing evidence that this woman ever decided she wanted to die if she was in those circumstances. And that's the only thing the U.S. Supreme Court decided. The United States Supreme Court did not decide that there was a constitutional right to life or death on your own choice. That was not part of the case that was before that court. So the U.S. Supreme Court sent the case back down to Missouri after reaching its decision. the Missouri Supreme Court sent the case back down to the Circuit Court in Jasper County, and they had a new trial. And in that case, the people who wanted to put Nancy under came up with friends. Somehow they came up with friends who said, "Oh, I've heard Nancy say that she didn't want to live in cases like that when they've seen news accounts of it." And it was on that kind of real, what I think is flimsy evidence, that she was declared to be incompetent, and they decided that she could be starved. Now, it also helped that when the case reached the Circuit Court, it was right before an election for governor, and the state of Missouri was one of the parties, like I may have said before, because it was at a state hospital where all this was going on. We got a change from John Ashcroft as governor, said very pro-life governor. His administration was pro-life, deprived of water and hydration, to Jay Nixon as governor, and she ultimately died from that, not pro-life. So that's Jay Nixon, the way that the informed consent is supposed to work. That's the way that the weighing is done in these cases. Okay. When the Missouri Right to Life pulled the state out of the power of attorney and gave up, an agent is appointed. It's up to the principal, the patient, future patient, I should say, that the name should be filled in with whoever he or she picks. Totally up to her. Now, the person involved can't be forced into becoming an agent or a surrogate. The person that's an agent or a surrogate has to consent to serve. So we don't foist this on somebody unknowingly, and then they're suddenly stuck with an obligation. It's the best thing to happen if right after the appointment, which would be made after a conversation with that person on whether or not they would consent, that another conference take place sometime soon, right after that or right before it even, on life and death issues in general. What would the patient want in certain circumstances, assuming hypothetically a lot of other things? And just reading the list of principles of the Missouri Right to Life Durable Power of Attorney, where the principles are set out that I mentioned in the first segment of this presentation. The agent and the principal need to discuss these things about what happens if, and what I believe in, and is life ever worthless or not. So the agent has the background to know what the principal wants when the time actually comes, which could be 20 or 30 years later after the agent is appointed. Now, the agent won't actually exercise any powers until there's a determination of incapacity. So we have the principles of pro-life activity here written into our durable power of attorney for healthcare, so that they're in front of them, and the 20 or 30 years doesn't mean that they've been lost to memory. They're going to be right there in the durable power of attorney. And I don't know of any other organization that sponsors that kind of feature in its durable powers of attorney. I think it's unique to ours. So after the conference and after the study of the principles that the pro-life agent is to carry forward, we reached a discussion of the process of decision-making. And I mentioned the types of things that are involved with informed consent, and that's what the agent is going to be primarily doing when he or she gets started on the assignment when incapacity actually occurs. The agent will have to give a copy of the durable power of attorney to the healthcare facility if it hasn't been done already, and then the agent will need to have the doctors tell what it is that is a main problem, what the other problems might be, and all the other things we discussed in terms of how a decision is made. It boils down to a medical assessment that the doctors provide to the agent, and a moral assessment, which the agent performs him or herself, knowing what the wishes of the patient were when the durable power of attorney was created. And the assessment of moral issues is the weighing process that I mentioned in the first segment of this video, where the weighing of burdens and benefits take place, and the ultimate decision is going to be up to the agent. Now, it might be a daunting task. Agents are going to be presented with a lot of medical jargon, a lot of medical issues. The agent's going to have to be pretty, I think, straightforward and energetic in gathering information. The agent needs to make sure that medical terms are explained and not left to be unknown or kind of unknowable and without the background that the doctors have. You got to know what the doctor's talking about. And then with all the information that we discussed before, it could be a complex decision of weighing this against this. A lot of it's going to depend on good judgment. It's going to depend on the good faith of the agent and trying to do what the principal wanted done and not what the agent might want to do for him or herself. And that, by the way, is a legal obligation to act that way, so that it's a legal obligation to do what the principal wanted or may have wanted in light of the principles involved, rather than the agent's own beliefs on what's the best to do. And it's a moral obligation as well as a legal obligation. And there's no penalty, there's nothing wrong with the agent consulting with other people about what he or she should do. You know, if the agent has maybe a relative who's a doctor, I speak from experience because one of my daughters is a doctor. It's a very good thing to have. But you find somebody who knows a little bit more than you do maybe about the agent, or about the problem, and you discuss it with them. Moral issues that it may be involved, discuss it with a clergyman, somebody who has more of a command of the moral side of things. That's to be encouraged. It may be that there isn't time to arrange that kind of thing. Well, the only answer is the agent should do the best job that he or she can do. Just be diligent, be forward if necessary to deal with doctors who are going to maybe try to browbeat somebody into submitting to a course of treatment that the agent knows the principal wouldn't want or wouldn't have wanted. And then be at peace. An agent who does these things is going to be seen as having done a reasonable job in the circumstances. Perfection, there's no such thing as perfection in these things. And therefore, they ought to be at peace with themselves once they go through the process of decision making. And it's sound decisions based on what the principal would have wanted that we're looking for, and that ultimately is the best the agent can do, and that's what the result should be. There are problems with check-the-box systems of other forms for durable powers of attorney. If you go online, there's any number of durable powers of attorney that can be sent to you as forms. A lot of them just are checklists. If you're incapacitated, you want X. Withhold food, Y. Withhold things like surgery or other invasive procedures, Z. Withhold, I've seen them withhold all antibiotics. Those categories are so broad that anybody can use them, or anybody can think of a meaning for them and fit. They are not what you need in a durable power of attorney. So people won't see check boxes on the Missouri Right to Life proposed durable power of attorney with health care. And let me end this way. Advance directives and durable powers of attorney can serve an important pro-life goal of providing legal protection to patients whose decisions are placed in the hands of their health care agents. Pro-life persons can prepare a pro-life durable power of attorney for health care to protect themselves from other people in health facilities that would prefer the patient's death to continued life. This makes it possible to attain the blessings of making things right with our family, our friends, our neighbors, and perhaps even with ourselves when the time comes. For people of faith, it is especially a time to be reconciled to God and also to pray for others, especially family members who are helping him or her. These blessings are of great value as life comes to its natural end. And that's what we're trying to safeguard with the durable power of attorney for healthcare, a natural end to a person's life. So thank you for your attention. I'll go through the form of the Missouri Right to Life durable power of attorney very shortly here. There's a form, there's a set of instructions called Completing the Missouri Right to Life Durable Power of Attorney for Healthcare that will accompany the form for the durable power of attorney for healthcare. It's useful to read the entire durable power of attorney before you fill in the form. You can change whatever you want, really, in the form. It's just a form, and it's changeable, but you need to know what you're doing. You don't want to change something that will make it more pro-death than you want it to be. So I urge people to see attorneys about the form of the durable power of attorney and the signing requirements and things like that. There aren't very many attorneys that are pro-life, unfortunately, especially in this area. We find attorneys that are against abortion, but it's harder to find attorneys who want to avoid questions about, or it's harder to find attorneys that really support the pro-life viewpoint on end-of-life issues. They're all for language in their durable powers of attorney, especially the ones that attorneys for elderly people often have, that says if I'm unconscious and can't make my own decisions and I'm in pain and it looks like I'm going to die soon, just go ahead and withhold water and anything else from me. So they don't even get to check the box. You have to check the language in the attorney's work product itself. And the Missouri Durable Power of Attorney is going to be discussed with attorneys with that mindset too. So you've got to make sure you understand and make sure that your attorney understands where you're coming from on this. And that's another good reason to have the principles, life-giving principles, pro-life principles, right there in the document itself, rather than having it be the subject of letters or not written at all. So the very first thing you may want to do is, if you have an attorney that doesn't seem too interested or too much in favor of doing what you want in the written part of the durable power of attorney, and you want to change a little bit in our forms, find a pro-life attorney if you can, and get their advice. So I've had a situation a couple of times where I did durable powers of attorney for friends, and they've seen one attorney for most of what they've got in their durable power of attorney, but they've also seen a good Christian lawyer that I referred them to about the pro-life parts of it. And that can be done. There's nothing wrong with having 2 or 3 attorneys involved in this situation. So what you actually end up doing, if you use the durable power of attorney as it's proposed, is on the first page, there'll be blanks for you to fill in your name and your agent that you're appointing. That may be followed there or in another place in the durable power of attorney by having alternative agents appointed if your first agent for some reason can't serve. So the agent may be, or the language may be, I hereby appoint John Doe to be my healthcare power or my healthcare agent in this power of attorney, and if he is incapable or unable to serve, then I appoint Jane Roe to be the agent, and you can even have a second alternative there. So those are the identity blanks to fill in. Then in one paragraph, there's a set of blanks that has to indicate how many doctors are required to declare you incapacitated in order to qualify for the agent to start acting on your behalf. Now, the agent isn't going to start acting on your behalf until the doctor certifies that you're incapacitated. The default number is 1 physician. Some people want the safeguard of 2 physicians to say that you're you're incapacitated, so that we don't have any funny business going on. So you have a choice of one physician to declare that, or requiring two physicians to require that. That's simply a check in the text. You'll be able to find it very, very quickly. And then there are the signature lines. There's one signature line with a notary that has to be involved. There are two other witnesses besides the notary that need to sign separately certificates of seeing you sign your signature to the completed durable power of attorney. That's really it. It's very, very simple to fill out once you have talked to your attorney. The hard part is talking to your agent and making sure that you understand, and he or she understands what you want in your end-of-life care. And that's why our durable power of attorney is arranged the way it is, and why I think that it's a better choice than other organizations' durable powers of attorney. So thank you very much for your attention. I hope that my explanation has been clear. You can send questions if you want to the main office of Missouri Right to Life, and they'll be forwarded to me. And thank you for your attention. Thank you.